Yes, Mr. Cordero.
My Lord. We pass now more deeply into the world of tax avoidance and creative structuring with Bookit, which the court will find at page 721 of the electronic bundle. And that is a case dated 2016. And in this case, the European Court was faced with a situation in which it had made its ruling in Everything Everywhere, which you just saw shortly ago, and yet a case comes before it with thinly disguised features of Everything Everywhere, but with one supposedly critical change, namely that that there are two suppliers rather than one. So Everything Everywhere was defeated because it was, of course, possible for the court to say to Everything Everywhere, who supplied both the telephones and the purported exempt service, well, we can coalesce those because you're one supplier, and so that's the end of that. So the next version, which came out, is the Bookit version, NEC as well, where tickets for an event are sold either as, well, they're sold as agent for an event supplier, Odeon Cinemas in this case, but the agent also purports to make a separate supply to the customer in respect of which exemption is claimed, thereby supposedly getting around the court's ability to hold that one can coalesce the two and eradicate the problem through coalescing rather than denying any freestanding potential to exemption to the new category. And as we'll see, there's a very forceful response from the CJEU, which we'll come to, but it still had to work out the legal position, of course, which it duly did. So, and the same judges decided both this and the next case. I will therefore take the next case very lightly. I will just point out one typo. So we'll just get into the detail for Bookit. And then, of course, that then takes us to DPAS. So Bookit 721 of the electronic bundle. No Advocate General, presumably because the court did not foresee its task as involving any change in the law, and a succinct statement of the facts, probably at 723. At 10, the referring court states that Odeon cinema ticket sales are made either at counters and automatic ticket machines at cinemas, or by telephone, via a call centre, or via the internet. Counter sales are made by Odeon employees. With respect to those sales, as for those made at automatic ticket machines and cinemas, Bookit provides card handling services to Odeon, but charges neither Odeon nor customers any fee for those services. Telephone and internet sales are made by Bookit, acting as agent for Odeon. With respect to those sales, the purchase of tickets by debit card or credit card involves the payment by the customer of the price of the ticket and also the card handling fee. In the relevant periods, the fee varied between 65 and 75 pence per transaction. The referring court states that throughout the relevant period, the debit card and credit card payments received by Bookit from customers buying tickets for the Odeon cinemas were processed by a bank known as the merchant acquirer under a merchant services agreement. That agreement provided that the merchant acquirer should credit Bookit's account with the total sum of the transactions in respect of which the relevant card transaction data was presented to it, The agreement also provided that Bookit, or as applicable Odeon, was obliged first to obtain from the merchant acquirer an authorization code issued by the bank of the cardholder, that bank being the card issuer, which signifies in essence that the card is valid and that there are funds in the account, before making any sale, and second, to ensure that that code was included in a file known as the settlement file, which includes the card transaction data, which has to be transmitted to the merchant acquirer at the end of the day with a view to completing the payments. And they then, at 13, refer to a separate agreement between Data Cash and Bookit and Odeon respectively, which I don't think is just a communication agreement, so it doesn't really add. The 14, the Reverend Court explains that in practice the purchase of a cinema ticket by telephone, via internet, includes the following stages. First, customer provides Bookit with the relevant data concerning the debit or credit card he wants to use, such as name and address, card holder, card number, security number, at the back of the card data, which Bookit sends via Data Cash to the merchant acquirer. The latter transmits the data to the card issuer, which, if the data is accepted, ring-fences the money and transmits an authorization code to the merchant acquirer. Merchant acquirer via Data Cash transmits that code to Bookit, which on receipt examines whether the requested cinema seats are still available. If so, the tickets are allocated to the customer and the transaction is completed by Bookit, which receives from Odeon confirmation of the reservation stating that an amount in consideration of the ordered tickets together with an amount payable to Bookit as a booking fee has been or will be charged to the customer's card. Next, as part of the each cinema's end-of-day process, Bookit transmits to Data Cash the payment information that it has collated in the form of settlement files that include, for each transaction, the card payment data, card issuer's authorization code. Data Cash then sends that to the merchant acquirer, a batch file comprising all the transactions entered into in the course of the day for transmission to the various card issuers, which triggers payment by the card issuers to the merchant acquirer. The merchant acquirer then credits Bookit's bank account with the funds concerned, and finally Bookit transfers to the Odeon the ticket sale revenue and retains the card handling fees. The Referring Court states that Bookit's role thus involves, in part, a supply of a service as an agent of Odeon in selling tickets, and in part the supply to purchasers of those tickets of card handling services consisting in obtaining card information from the customer, transmitting that information to the merchant acquirer, obtaining an authorization code from the merchant acquirer, and retransmitting the card information, including the authorization code to the merchant acquirer, as part of the settlement process. And I stop reading. That gives you the full picture. There's an observation that at 17 that Bookit had to do whatever it did, otherwise there wouldn't be payment, so to that extent it was essential. And the debate then follows as to whether it's in what used to be Article 13 BD3 territory. What then happens at 725 is a heading, preliminary observations. I will only summarize this. Suffice it to say that in the NEC case, there is an almost identically worded preliminary observation. Both cases were decided by the same panel on pretty much the same day. And what this essentially says is, we've already decided everything everywhere, and the fact that there's a split of these purported supplies has no decisive significance. 27, the court will look at economic and commercial reality. There is at 28 a hint that it may well be that the National Court really should have delved a little more deeply. Obviously, it didn't. It says at 28, in the light of the foregoing, it's for the referring court to determine whether, in the main proceedings, the card handling service provided by Bookit should be considered for the purpose of application of VAT as a service that is ancillary to the sale of cinema tickets concerned, or as a service that is ancillary to another principal service, that is supplied by Bookit to the purchasers of those tickets, which might be the remote reservation or purchase in advance of cinema tickets, and consequently as forming with that principal supply, single supply, with the result that the service should receive the same tax treatment as the principal supply. The point of all of that is it's a very unusual manifestation of judicial creativity for the court to suggest to other courts and all the tax-gathering authorities arguments that could or should have been run to defeat the planning. It's only background, but it indicates perhaps a particularly forceful state of mind of the court when it came to the actual analysis, which bears on this court's deliberations, which starts at 30. I've already drawn to the court's attention the words in paragraph 36 about the transactions in question relating to the sphere of financial transactions. And what then follows at 38 are references to SDC. Perhaps I can just say for the transcript, references to paragraphs in SDC appear at paragraph 38, SDC 53 and 66, paragraph 39, paragraph 40, paragraph 66, paragraph 43, paragraph 50 and 65, and paragraph 45 is deeply embedded in SDC. So having got that out of the way, if I could just direct the court's attention to the analysis, because we're now at the centre of the debate. So 39, 40, 41, and so on are all mainstream references, and the actual reasoning starts at 45. That's strict construction, so therefore no reason to read 45 aloud. Secondly, or rather next at 46, secondly, obtaining by the provider of that service from the purchaser of the data pertaining to the payment card that the purchaser wishes to use, the transmission of that data by that service provider to its merchant acquirer, the receipt by that service provider of the authorization code provided by the card issuer, and the retransmission by that service provider to its merchant acquirer at the end of the day, at the end of day settlement file, including inter alia the authorization codes relating to the sales effective, cannot, taken individually or together, be regarded as performing a specific and essential function of a payment or transfer transaction for the purposes of 135(1)(d) of the directive. And then at 47 it says there's no dispute, given that description, that the provider of such a service does not itself directly debit or credit the accounts concerned, and that it does not act by accounting entries, and that it does not even instruct such debit or credit, since it is the purchaser who, by using his or her payment card to make a purchase, decides that his or her account will be debited in favour of a third party. So pausing there, it's essentially saying the action is taking place somewhere else, and it outlines where. At 48, recalling what was said by the Commission, it says, moreover, as stated by the European Commission at the hearing, the settlement files submitted by a trader who is a service provider to its merchant acquirer are nothing other than a request to receive a payment electronically. The purpose of the retransmission of such an end-of-day file is thus merely to inform the payment system concerned that a previously authorized sale has in fact been made. That retransmission cannot therefore be regarded as executing the payment or transfer concerned or as fulfilling in effect the specific and essential functions. The fact that such a file is confined to producing the data and codes pertaining to sales that have actually been made, and therefore to sales where the availability of the ticket desired by the customer has been confirmed is of no significance in that regard, since that fact is inherent to the very nature of such a file. So pausing again, effectively the court is saying that retransmission comes too late to be the one that affects a change in the legal and financial landscape. It's rather like the end-of-day file in Cardpoint. It's just recording history that has already occurred. There's another, even more important point, though, in the paragraph, which is the early reference to, in the first sentence, to it being nothing other than a request to receive a payment electronically. So what the court is saying here for the first time, because this is the first time it has been presented with a putative Article 13BD3 supply, where the supplier is also the creditor. And that's fundamental. And I'm back to my original theme about the sphere of financial transactions and the exemption. If I could just make this point before I read on. It's inherent, we say, in that exemption, and also the cases that one has read up to this point, that the involvement of the taxpayer is, in a sense, as the servant of the machine, which is the financial payment system. So the bank subcontracts, it needs someone to send messages, they might be taxable, they might be exempt. But the taxpayer tends the machine, it's asked to do this or that, and the machine functions. The taxpayer is not a consumer of financial services, it doesn't have a stake of any kind in the transactions that it is servicing. It is simply giving certain very precise assistance. As I say, that might or might not be taxable, that's not the point. Once we move into these cases, one has got a participant in the supply chain mixing up with its taxable supplies, some exempt supplies, but I believe I can say this, in all the cases, it has some kind of financial interest, i.e. it has its own debt that needs to be paid. It's logical because it's trying to split its turnover. It has a potential inflow of money, but it wants to segregate some of that and ring-fence that.
But by it, in this context, are you talking about the taxpayer or the taxpayer's customer? Took it or owed it?
I do apologise because the pronoun, there are too many candidates. So it is the claimant, the party that's claiming to make the exempt 13BD3 supply. In the book it type case, it's one of these supplies of a card handling service.
So you're saying that the card handler mixes up taxable supplies with some exempt supplies. But the taxable supplies are not the cinema tickets, they're something else.
The agency function in selling them. So that's a supply to the cinema.
But Bookit didn't sort of pre-buy a group of cinema tickets and sell them, so it never took the risk of unsold cinema.
It made its checks, and then they checked if got the green light from the merchant, through the merchant acquirer from the card issuer's bank. They then checked if the seats were still available. So yes, my lady, there was no risk taken. But what's inherent in this case and the others is that, in this case, for example, the message to the merchant acquirer was essentially a message saying, we've had so many sales today, you owe us X in respect because you've underwritten the use of these various debit and credit cards during the day. This point will become more obvious but it is a point of considerable importance because it moves us out of the situations which are wholly in the sphere of financial transactions. So let me read on, and hopefully the point will develop. So 47, I think I've read, and indeed I think 48. The first line, as I say, that in that first line of 48, a trader who is a service provider submitting settlement files to a merchant acquirer are nothing other than a request to receive a payment electronically. And what's inherent in that, we say, it can never be a supply by me to a customer of mine that from whom I have taken payment by a credit card to send a message on my own behalf at the end of the day to the merchant acquirer who's agreed to support my business to get what is owed to me. It's entirely my own affair. Number one, I'm not making any supply to my customer thereby. And number two, it's not the sort of transaction that 13BD3 is aimed at. So I will and then there's the past tense point, which I've already made at 48. At 49, the court recounts the sending of the authorization codes, and the first sentence says that this is, if I can take it up at line 3, only an authorization to proceed with a sale which the card issuer concerned via the merchant acquirer supplies to the service provider. There is again no question of a specific function that is essential to the transfer of ownership of the funds concerned. Accordingly, where such a code is obtained by the provider of that service directly from the card issuer, that's the bank, or rather via its merchant acquirer, is of no relevance to the determination of whether a card handling service, such as that at issue in the main proceedings, does or doesn't fall within the scope of the exemption at issue. I won't read paragraph 50 aloud, I'll just summarize it. It makes the point that Bookett assumed no liability to anyone else that money would in fact turn up, and it didn't in any sense underwrite or guarantee that the money would arrive. So at 51, they conclude that the provider of a card handling service such as that at issue in the main proceedings plays no specific and essential part in achieving the changes in the legal and financial situation that are the result of the transfer of ownership of funds concerned, and that according to the case law can be said to be characteristic of a transaction concerning payments or transfers that is exempted under Article 1351D of the VAT Directive, but does no more than provide technical and administrative assistance for the obtaining of information, the communication of that information to its merchant acquirer, and to receive by the same means the communication of information that enables it to effect a sale and to receive the corresponding funds. So there the court ties its conclusion in with the making of the taxable retail supply and the receipt by the party claiming to be supplying an exempt service to the customer of simply what's due to it under the contracts it's already made with its merchant acquirer.
The sale of cinema tickets would be a taxable supply.
Entirely, my lady.
Yes.
Absolutely. And we see the point of it all at 54, but perhaps in 53 they focus on the economic reality, which is all that's happening is there's an exchange of information between a trader and its merchant acquirer, so that the trader can get paid at the end of the day. And then at 54, quote, it may be added first that such a service cannot be deemed by its nature a financial transaction for the purposes of Article 1351B2G of the VAT Directive, unless the view is taken that any trader that takes steps necessary for the receipt of payment of a debit or credit card is undertaking a financial transaction for the purpose of those provisions, which would render the concept meaningless and would be contrary to the requirement that VAT exemptions must be interpreted strictly. And that, I submit, confirms that once the trader intrudes itself into the chain of supply, in some taxable context, it doesn't have to be, and becomes a customer for the very payment that it is claiming to trigger, it is, for whatever reason, this has been held here at para 54, outside the exemption. The reasons are fairly obvious, and in fact are stated at para 56, which is this: if a card handling service such as that at issue in the main proceedings is subject to VAT, there are no such difficulties. I've skipped over Velvet and Steel, but for no particular reason. But Velvet and Steel is mentioned in between. But at 56, second sentence, in particular, the tax base, which corresponds to the consideration received in exchange for that service, namely the fee charged to the purchaser of the ticket for that service, can readily be determined, and such a transaction does not involve the provision of any credit to the purchaser by the provider of that service. Such a service cannot, therefore, properly be subject of an exemption under Article 1351D. So what the court has done, for good measure, having already defeated the arrangement by paragraph 51, it then moves on the next page to some additional reasons, which include, obviously, that if this had succeeded, every trader could characterize its own receipt of payment from its merchant acquirer at the end of the day as some kind of financial service to its customers, which would erode the tax.
Except that they would then be in EE, in everything everywhere territory, wouldn't it? There'd be a composite supply, and the fact that part of that supply is that you process their credit card doesn't mean you can split out a teeny bit and say that that's an exempt supply. So,
but hence the introduction of a secondary company which makes...
Yes, and then they say, well, maybe National Court, you should have treated this as a composite supply, of which this bit is still a small bit.
Yes.
But you didn't do that, so we have to address the question you asked and say it's still not a financial transaction. But they don't, do you say they're linking that in some way to the fact that what we're talking about here is cinema tickets, which is at base a taxable supply?
It's always in the background, particularly given the preliminary observations. But analytically, to answer your question directly, they analyse the messaging as in two or three ways. Mere exchange of information, therefore, doesn't register. Secondly, the file to the merchant acquirer at the end of the day simply comes too late. The money's already left the account of the cinema goer. And thirdly, the most indigestible part of it all is the collecting at the end of the day from the merchant acquirer, and they deal with that by saying that's, my words, you're essentially consuming a supply from the merchant acquirer, and that is not the sort of thing at which Article 13BD3 is aimed. And that's 54. They say it's by its nature not the sort of financial transaction or a financial transaction for the purposes of Article 1351B.
The such a service in that first part of paragraph 54 is referring back to the card handling services.
Indeed, and what they were saying was the card handling service, this phrase which has been engendered over the last few years, card handling service, where the attempt is made to hook, because that's a neutral phrase, that doesn't necessarily tell you if it's exempt or taxable. So they have to somehow get into para 66 of Sparkasernes, and they do that by pointing to a money movement at the end of the day, which satisfies, in fact, probably not the obligation of the cinema goer to the cinema. If it's a credit card, the obligation of the cinema goer to pay is replaced by the obligation of the merchant acquirer to pay. But it satisfies the obligation of the merchant acquirer under its contract with Bookit to make Bookit whole at the end of the day. And what they're saying is that transaction, 54, that's not the kind of transaction which this exemption is aimed at. I've added a layer of analysis in my presentation, which I hope hasn't overcomplicated it, to try and make sense of that, in this sense that why can the court say that? It can say that because the taxpayer has intruded itself into the supply chain and is pointing to a movement of money between it and its merchant acquirer, to which the cinema goer is completely at arm's length and has no knowledge of or interest in, because any seller who accepts credit cards will already have in the background a deal with a merchant acquirer, enabling it. It will show the logo of the card company, and it will have a deal whereby the member of the public can use the card, can see the film, and at the end of the day or the end of the month, the merchant acquirer, having secured its own position with the issuing bank, will then make the Bookit party whole. So there are about 4 different reasons why the planning failed. But no change at all in the underlying case law stemming from SDC. So I was proposing to briefly dip into NEC, but very briefly, because it's the same story. Same judges, same day, as I've said.
Yes, do allow yourself enough time, obviously, for the...
I'm very conscious.
The main part of the menu.
Yeah, yes, indeed. So the only thing I say about NEC is at paragraph 31 on page 740, the word not is omitted in the second line. It should read, according to the nature of the services provided and not in terms of the person supplying. So DPAS then, that was a correction to paragraph 31 of NEC. DPAS at page 745, same panel again 2 years later, and we have a different arrangement. On this occasion, we still have a bifurcation of supply, in the sense that DPAS is supplying an administration service to dentists, and originally that had included an exempt or purportedly exempt component in terms of handling monies due to the dentists. because of a parallel case, AXA, Den Plan, which I'm not proposing to trouble you with because for various reasons. That's on the debt collection point. It became apparent to DPAS that it was vulnerable to a debt collection argument, or that's what it thought it was, if it went on supplying the payment collection service to the dentists. So it flipped through 180 degrees, and it began to supply the patients. So it was a main supply with directed at the still at the dentists, who, it was a white label situation. They could sell their services and there would be regular payments and an insurance policy and so forth. But then there was a separate supply to the patients of this payment handling service. So it's not a card handling service, but a payment handling service. But in essence, it's the same thing. The relationship between it and Bookit and NEC is simply, it's covered in the, there isn't time to go there, but there's a supplementary, a small supplementary file which simply charts the two decisions of the upper tribunal in this case. The first one was to park the issue pending the outcome of NEC and Bookit. Then when that came, it didn't answer the question that the tribunal wanted, so it made its own reference to the European Court, and this was the result. And there is an Advocate General, there is no preliminary observation, and if one comes first of all to the court, which starts at 762, the summary of the facts appears, material summary. It's complex, one doesn't need the history, one just needs to know how it stood at the time of the court came to decide. So at 11, para 11 on 763, the court records that there was a simple bilateral arrangement. Then at 12, AXA came out, as I've just said. So if one turns the page, one then has at 13 and 14 what happened next. So 13, following that judgment, DPAS restructured the contractual aspects of its dental plans with the intention henceforth of making, as from 1 January 2012, supplies of services not only to dentists but also to patients. 14, thus, first by letter dated 8 September 11, addressed to dentist clients, DPAS informed them that in order not to increase its prices as a consequence of the judgment in AXA, it would be making certain purely administrative changes without affecting the amounts charged to them or to their patients, and without making any, quote, practical difference to the current arrangements, end quote. And then the new general terms are set out at 16 and 17. The emphasis again is at H is purely administrative, and then at 18, in that respect, each patient was requested to sign an acceptance form, or as the case may be, an authorization form, stating that the patient agreed that DPAS would manage and administer payments due under the dental plan, and that the patient authorized DPAS to deduct for that purpose a monthly charge from the monthly payment agreed with the dentist. And just pausing there, and that was going to be done by direct debit. And it's essentially for the flowing out of the defeat of this that the commissioners are taking the point that they're taking in this case. I should say that there, at no point in the DPAS litigation, either in the UK or in Luxembourg, did the commissioners in any, I'm informed, in any way criticise or suggest that the SDC line of cases was lacking in any material respect. So one goes into this hearing with that knowledge in mind. And then if one then comes to the analysis at page 767, at 31 there's the reference, now all too familiar, to the sphere of financial transactions. 33, execution of an order being the movement of money from one bank account to another. And then if one comes to, 39 on page 768, in the present case, it's apparent from the order for reference that the supply of services at issue in the main proceedings consists for DPAS first in requesting from the financial institution of the patient who entered into a dental plan pursuant to a direct debit mandate that a predetermined sum of money be transferred from the patient's bank account to DPAS's account. And secondly, in subsequently requesting the financial institution with which it holds its account to transfer that sum from that account to the respective bank accounts of the dentist and the patient's insurer, DPAS retaining part of that sum as remuneration due to it by the patient for that transaction, which DPAS itself describes as management payments due by the patient under dental plans which he has taken out. 40. Such a supply of services does not, as such, affect the legal and financial changes which characterize the transfer of a sum of money within the meaning of the case law referred to in paras 33 to 38, much of which I have cited, of the present judgment, but is administrative in nature. 41, DPAS doesn't itself carry out the transfers or the materialization of the relevant bank accounts of the sums of money agreed in the context of the dental plans at issue in the main proceedings, but asks the relevant financial institutions to carry out those transfers. And by contrast, as the tax authority contends, a supply of services such as that at issue in the main proceedings is comparable to the card handling fees which were at issue in the case giving rise to the judgment in Bookit. And then they repeat what the characteristics were. 42, as the Advocate General has also observed at point 51 of his opinion, a supply of services such as that at issue in the main proceedings is merely a step prior to the transactions concerning payments and transfers covered by Article 1351D of the Directive. 43 just notes that the fact that it might be essential doesn't make any difference. 44 makes the point that there's no liability. And then 45, as regards, moreover, the general scheme and purpose of the VAT directive, it should be noted first that the transactions exempted under Article 1351D2F of the directive, even though they do not necessarily have to be carried out by a bank or a financial institution, are by their nature financial transactions. However, as has been established in paras 40 and 41 of the present judgment, a provision of services such as that at issue in the main proceedings is administrative in nature. And we say that enables this case to be easily distinguished without upsetting any of the prior cases.
I can see that you would have a point if they had referred to the fact that Bookit was about a taxable supply of cinema tickets, and this is about a taxable supply of dental services, whereas in SDC I think it was an exempt supply that the transaction was linked with.
Yeah.
But although one might have thought that would be a potential reason that they could have given, how do you say that that is in fact the reason that
I've skated over something, I apologise. Dentistry is exempt. So the whole point of this was, and therefore the dentists couldn't, if they had kept the original format and as a result of AXA had suffered VAT on the whole of their turnover, the dentists could not have deducted any of it. And I apologise for skating over that.
If they had incurred VAT on the service that DPAS was supplying them,
Yes.
they would not have been able to recover that because their dental services are exempt.
So the dentists are the equivalent. It's a slightly different story, but the dentists have the same problem that the banks have because they're all exempt and they can't therefore deduct. So what's happened here is there's still a carving out of what, because of its administrative nature, would be a taxable supply of administrative services to dentists. It's a package. And there is still the same motive to discover or carve out an exempt element in order that the dentists don't have to pay it. They've actually taken it off the dentist's bill and redirected it to the patient's bill, but the patient won't be able to deduct input tax. So the essential problem is the same as the other cases. Something which is prima facie taxable has been in one part redefined, in inverted commas, as exempt, and the thing itself, the court holds on the individual facts of this case, which are obviously vastly different from the case before this court. The court has held that on this case, facts, it's administrative in nature. And I gloss the case by saying, furthermore, the movement of money in question is a movement into the coffers of the very entity which is saying that it is making the Article 13 BD3 transaction. So it is, to that extent, a consumer of banking services. And it may well be that that is what the court had in mind when it said that these are at 42, this is merely a step prior to the transactions concerning payments and transfers covered by Article 1351D. The analogue of that would be the message to the merchant acquirer in Bookit, where Bookit said, "Can we have our money now?" The merchant acquirer then sends it. But once again, the landscape is strewn with reasons to distinguish this case from both my client's case and the generality, we say, of Article 13 BD3 type cases. If I just repeat it briefly, the point I make is that this is a very precise exemption. It inheres in movement of money whereby a debt rises and falls, or a payment is made, banking entries occur, and it is supplying a transaction which has that effect in really rather a pure format, it would appear, that will trigger the exemption. And once it's muddied by, for example, the purported supplier of the exempt transaction having an interest in the very movement of money concerned, then the court simply says no, that won't do.
But if it doesn't have an interest in the movement of money concerned, then it's called just a data handler and it's not exempt then either.
Well, if it is supplying the sort of thing that my clients or FDR or SDC supply, and I always have to come back to this, to a bank, then we know that the supply has a role to play in the genuine world of the sphere of financial transactions, because banks are interested in the movement of money. it's conceivable that we know that you don't have to be a bank to make that supply, and it may be that you could, I've never seen such a case, could have a case in which that supply is made to entities which are not banks. But all we have to go on in the case law is that per law justice laws, it's the pro and con entries in banks that move money, and where you're making a supply to such an entity whose entire business is pros and cons, and you're assisting them in that process by, as it were, taking out of their hands the triggering, then that, I submit, is enough to achieve the exemption. The Court of Appeal says no. I'll show you that passage in just 1 second. That's what the case comes down to. Whether these rather murky cases, and this we're still in, card point is still ahead of us in this case, DPAS. So we know the court went on in its very workmanlike way, looking very precisely at when messages cross the line. But that's the core of it. So the court, I wonder if with this in mind, I can just open the Court of Appeal for a moment and show you what I would submit is a contrast. So if we go to the Court of Appeal, that is to say, Lady Justice Simler delivered the leading judgment. Page 206, it's in two parts, 84 to 93, and then Her Ladyship takes it up again at 98, and it goes through to 102. The respectful criticisms that we make perhaps begin at 84, Her Ladyship focuses on the purely automatic point. I've already indicated that that's not of itself critical. Things are automatic if, as it were, the force of your authority is very strong and no one dare check it, but it can nonetheless be a legal obligation or a practical obligation, even if it takes time to come through. But Her Ladyship encapsulates FDR with great respect correctly at 84, and later, obviously, she concludes that FDR was wrongly, it is now can be seen to be wrongly decided. But then at 85, she says this, but as the discussion of subsequent decisions of the CJEU in Nordea, Bookit, and NEC above demonstrates, the CJEU confronted and addressed, as a matter of general principle, the question whether giving instructions that triggered an automatic process leading inevitably to payment was or could be sufficient. These cases elaborated on the principles established by SDC. They made clear, as did SDC, that where a company itself debits or credits an account directly or intervenes by way of accounting entries on the accounts of the same account holder, that permits a finding that there is a transfer or payment within Article 1351D. However, in Bookit 2, NEC, etc., such a finding was impossible. The exemption didn't apply because the services supplied could not, taken individually or together, be regarded as performing a specific and essential function of a payment or transfer transaction for the purposes of EU law, because the supplier didn't itself directly debit or credit the accounts concerned or act by means of accounting entries, nor did the supplier assume any liability as regards the achievement of the changes in the legal and financial situation that are characteristic of the existence of an exempted transaction or payment transaction. Now, pausing there, I would respectfully submit that the cases were not grappling with any issue to do with automatic movement. It's hardly featured in the review. and that may not be a very significant observation. But also, it would appear that her ladyship is, when she says they make clear, as did SDC, certain means are available to move money, that they are prima facie in line with SDC. But then, at the start of '86, the CJEU, speaking of these cases, the CJEU concluded clearly and unambiguously that actual execution is necessary to qualify as a transaction concerning transfer or payment, and the mere giving of an instruction is not sufficient in itself, even if the instruction or order is indispensable to the transactions taking effect, and even if the instruction triggers an entirely automatic process leading to payment. Electronic messaging services in a payment chain that merely transmit information or instructions but do not themselves perform any of the functions of transmitting funds to constitute a transfer do not fall within the exemption. Just pausing there, there are various reasons in the cases why instructions failed to engender exemption. One, for example, in card point, the instruction came too late in the day. The movement had already occurred. Another, in book it and so forth, is that the instruction was simply to a debtor, a commercial debtor of the purported supplier of the exempt supply, merchant acquirer that is, asking for their money. And the same was true in DPAS, mutatis mutandis. So her ladyship doesn't at this point distinguish between electronic messaging which can trigger the movement of money and that which cannot. Then at 87 she discusses...
So just say again the reasons that you say that giving instruction failed in the previous case. You said in card point it became too late in the day insofar as they were relying on the end of day file going.
And the movements already had happened. And that, to some extent, forgive me, and then in the NEC Bookit cases, the instruction was to a debtor of the party claiming to be making the Article 13 BD3 supply, merchant acquirer or patient's bank. So what they're doing in both cases is...
And they were a debtor of whom, though?
Of the supplier of the exempt...
Bookit and NEC.
Yes. The merchant acquirer was a debtor of Bookit and NEC. It had no connection with the purchaser. It had a practical connection, but it had no contractual connection with the purchaser of the theatre tickets. It was simply part
Who
of...
had? The customer?
Yes. So the merchant acquirer, as my lady knows, the merchant acquirer simply enables a merchant to show the logo, and it persuades the merchant that it can safely take the card, and then it will at the end of the day, the end of the month, pay the merchant what its private arrangement, subject to obviously a commission. So what the court said in those cases was this has got nothing to do with the Article 13 BD3 exemption. Every time one demands money, one engenders potentially, hopefully, a movement in the banking system. You can't repackage that as a 13 BD3 supply, and that's why the court is so careful about maintaining, as it were, the purity of what that's about. If you come out of those cases and into the mainstream, FDR, SDC, I haven't shown you EDS, so I'll just take one moment to do that shortly. what the data handler is asked to do by the bank is to oil the wheels of the movement of money in this world of electronic messaging by taking on the messaging that the bank itself would normally do. As agent for the bank, it's cloaked to the bank's authority. It sends the messages that the bank would send. Through it, does send, and it charges the bank for that process. And it's a very bright line indeed between these rather murky cases and what the industry does, as exemplified by my clients.
But I can see there's a tension between what I think you're trying to say, which is that all that Target is doing is oiling the wheels, cloaked with Shawbrook's authority to execute the transactions, the transfers in a way which the court seems to be describing in these cases, and therefore, given that this is in the sphere of financial transactions and is an exempt supply, it should also fit within the exemption. But is that in tension with the other basic VAT idea, which is that if you are making exempt supplies, you have the advantage of that vis-à-vis your own customers, but you have the disadvantage that you can't recover input VAT?
No tension at all, because if my clients succeed in this litigation, they will not be able to recover their input VAT.
No, but your client won't. No,
my client.
No, but Shawbrook then pay less. They have less irrecoverable input VAT in their business.
Exactly. So we give up
more
indeed.
Yes.
And frankly, no one is ever quite sure how the equation works out. It is what it is. So my lady has put her figure exactly on it. We're arguing ourselves out of an input tax claim, but at least we're not passing it on to Shawbrook, who, whatever the outcome, will not be able to recover input tax. So if I can just move to the second part of the reasoning, and I won't go through it too closely. The second part of her ladyship's, or the court's reasoning, is at page 210, and it's paragraphs 99 and 100, where we say the court falls into error on a proper reading of the cases. At 98, somewhat off to the side, the point is made that it's questionable whether or not what my clients offer Shawbrook, viewed broadly, does form a distinct whole that fulfills the essential functions of a financial transaction. And the court goes on to say in 98 that Target doesn't provide loan originating services to Shawbrook, which is quite right, nor do we assess creditworthiness or value potential security or otherwise decide whether or not to make a loan or process the making of advances. And that is quite right. My current clients step into the narrative after the drawdown has taken place. However, I don't think it was, I'm not sure it was argued, but it certainly wasn't put to any of the witnesses that we were offering less than a commercially acceptable package for its own reasons. Shawbrook doesn't subcontract the drawdown, and that's its choice. But I think this is a reference to the EDS case, which I'll take you to very, very briefly, which was the follow-up case to FDR, where an entity which did do the drawdown and so on had the same argument as FDR. More importantly is 99 and 100. And at 99, the court acknowledges that, quote, Shawbrook has delegated part of its functions to Target. Target has full authority to bind Shawbrook, operates bank accounts on behalf of Shawbrook, and is responsible for matching payments to individual loan accounts and identifying missing payments. It does not itself debit or credit an account directly or intervene by way of accounting entries on the accounts of an account holder. The functions delegated to Target are limited to passing the necessary information to BACS to enable it to give the relevant instructions to the borrower's bank and Shawbrook's bank so that the transfer of funds can take place, and don't include the necessary steps ordinarily undertaken in effecting the transfer of funds or payment themselves. Just as a customer of a bank, including Shawbrook, doesn't effect a financial transaction by instructing their bank to make transfers or payments, equally a person with authority to give instructions on behalf of the bank's customer doesn't provide an exempt financial services. The transfers and payments are effected between the borrower's bank and Shawbrook's bank, and neither of these banks delegated any part of these functions to Target. My submission, that is putting the bar impossibly high for anyone to surpass it. First of all, we do intervene directly, I assert. Both.
Sorry, I didn't hear that.
First of all, I assert, my Lord, that we do intervene directly by means of the direct debit into the borrower's coffers, as it were, as we speak, with authority from Shawbrook and authority, pre-obtained authority from the customer, its bank. We speak to its bank and we ask for a sum of money to come out, and it does. So that is a direct intervention in my submission. And secondly, we do operate Shawbrook's accounts with its clearing bank. So we have our fingers in those various accounts in those various ways. And we do that through our messages to BACS. We've got my submissions on that. We believe that BACS is indeed exempt. And Lord Justice Law's words on that subject, we say, remain good law. And we do not know what the necessary steps ordinarily undertaken in effecting a transfer of funds or payments is, if it is not something to do with messaging, because that is the only way it can happen. And has been the case for a very long time. So the last sentence does come perilously close to a return to the Advocate General, as I've already said. Of course, neither of the banks has delegated its banking function to us, and it would be a rare situation were it to do that. Same respectful criticisms of paragraph 100, particularly, say, line 4, the sentence starting in other words. In other words, Target triggers the chain of steps leading to a transfer, but does not itself execute or effect the legal and financial changes which are characteristic of the transfer of the money. The fact that Target itself uses the BACS payment systems rather than instructing a financial institution to do so is a distinction without a difference. Likewise, that Target performs a legally significant service under authority within the chain of binding messages, as Mr. Cordaro described it, which results in alterations to payor and payee accounts, is not sufficient to qualify for exemption, even though it may be a necessary step in order for the payment to be made. Were it so, DPAS and the cases preceding DPAS would have been differently decided. So you have my submissions on that now. I won't repeat them. 101, I have already mentioned, we do assume up to £1 million of liability under Clause 13, page 305 of the bundle, and the debiting and crediting 102 of the borrower's accounts I've dealt with. So on this issue, there is only one other brief authority to refer to, which I...
You don't presumably assume liability for the borrower not being in funds to meet the...
No, we do not. We assume liability for making a mess of it, as it were, which we do not do, of course. The only other case which merits a very swift acknowledgement is the case of EDS, and I'll just find that. Apologies.
Yeah, just to be clear, the liability that's assumed, I think you told us, was a liability in damages up to £1 million.
Indeed. I mean, we promise, I paraphrase, we promise to do all the various technical things.
Yeah.
It must be implicit in that we promise to do that with due diligence and so forth.
Yeah.
EDS, I found it.
And this is found as a fact somewhere, is it?
It is the limitation clause is not found as a fact. It's in the contract at 305.
Right.
I'll double check that page number.
So it's a liability to the bank, is it?
It's a liability to Shawbrook.
Yeah.
It's 304. So there's an exclusion of liability and then a carve out to the exclusion. If I may, very quickly before passing on to other matters, and it's self-evident that I'm going to have to spend some of my reply budget today in terms of time. I'm reconciled to that, and so is my learned friend. So I will just go on, but I will have less time tomorrow.
Yes. Well, we'll see what progress we make, but you've obviously had to take us through the case law, and it may be that Ms. McCarthy may benefit from that tomorrow.
But I'm not spending her time until she tells me I can. So EDS. EDS is divider 19, page 880. I haven't mentioned it up to now. It's simply, as it were, first cousin of FDR. It's a 2003 case. So a couple of years or so after FDR. And if I can summarize the facts just very briefly, it's a very convenient case to cite because Lord Justice Jonathan Parker sets everything out on a single page. It is FDR's facts, but with an additional set of events at the front end. In other words, EDS assisted in the process of vetting borrowers and also using the back system in facilitating the drawdown of the original lending. So it was FDR plus, as it were. As a result of those front-end additional services, EDS, opened an additional front against the commissioners, which was that it was making supplies of negotiation under 13BD3. You can ignore all of that. I think it won the argument, but it is immaterial for today's purposes. The reason for citing the case is for Lord Justice, or the court's distillation at pages 911 and 912 of SDC. And what happens at page 911 is that Lord Justice Jonathan Parker at 125 boils everything down. I'm not troubling the court with any other details. But on the facts of that case, he speaks about the general guidance given by the Court of Justice and so forth. And he speaks at 131 about CPP and so on. What he says at 135 on page 912 is hopefully helpful. It's a series of bullet points with his distillation of where the law stands or stood in the wake of FDR and, more importantly, SDC. And it is, I won't read it or take you through it, it's all material we've seen elsewhere, but in my submission, it remains good law. Over the page at 136, he applies that to the facts of the case and agrees that it's an exempt package, and at 138 says there's been no extension. 140 and following are irrelevant because they deal with the other issue of negotiation and so forth. That completes my submissions on the initial and most important question, and I will turn with permission now to the second of the issues, which is much shorter, which is what could be described as the ATP point. Up to this point, I've been addressing the court on transactions concerning payment and transfers. You can't have payment and transfers without debts, I accept. But the emphasis, and vice versa, potentially, less inevitably, the emphasis slightly switches to debt in this sense that we keep the ledgers for the bank, and it is only those are the only ledgers that are kept. We say that and this is an English law banking point, essentially, the ledgers have legal significance. I'll show you briefly, or remind you briefly of the Mon case, but it's also in Lord Justice Law's judgment, and that there is therefore he or the party who keeps the ledger is recording the bank's position, and normally it wouldn't particularly matter, but if a payment fails after a receipt has been recorded, then in certain circumstances the debt will be as recorded rather than in terms of the actual position, and therefore it is legally significant that we keep the ledgers. This was also the case in FDR, and that was rejected by the Court of Appeal on the simple basis that when you can reconstruct the transactions from the bank accounts of Shawbrook, and the Court of Appeal was absolutely right to say you could do that, but it doesn't follow that you have an alternative means of evidence that the keeper of the ledger of the bank that is lending it isn't keeping a legally significant document. So you can see it's a very different type of point from what we've been looking at up to now. And I can take it relatively succinctly because it is a short point. The European basis for the point, before I go anywhere else, is the ATP case we haven't looked at. That is can be found at tab 11, page 688 of the bundle. As I say, this is all against the background that the only records of the transactions are kept by Target. That's the First Tier Tribunal, paragraph 42, at electronic page 249. So against that background, I invite the courts to look briefly at ATP, a complicated case, most of which is not relevant, to do with an entity that was charged with working out pensioners' respective percentage entitlement from a global pension fund. And it had the power to bindingly state X, Y, and Z will get X, Y, and Z percentages. So money didn't move. but nonetheless, debts were established, and to some extent, I guess, that would involve a transfer, but principally debts were established and the debt position was established. And it is this case that the court will have had in mind whenever you saw the phrase establishing a position by means of accounting entries. Saw that phrase in a few of this morning's cases. It's this process that the court had in mind. And if you'd be kind enough to turn to page 717, so, and that entity then said it would rather not add VAT to its bill. It's a purely managerial entity. So on a velvet and steel approach, some might say, oh, well, it should be taxable because it's obviously charging a fee for administrating. But that point wasn't relevant. So at 70, the court says, the services in respect of which eligibility for VAT exemption is contested in the case before the preparing court are referred to at para 35 above. It appears prima facie that some of those services are not of a purely technical nature. Rather, through the opening of accounts in the pension fund system and the crediting to those accounts of the contributions paid, they establish the rights of pension customers vis-à-vis the pension funds. The transactions by which the contributions are credited to pension customers' accounts appear to have the effect of transforming the claim held by a worker vis-à-vis his employer into a claim that the worker holds vis-à-vis the pension fund. So these are not bank accounts, these are, this is a ledger of entitlement. And then if one goes to the next page, to 718, at para 79, the court has held that a transfer is a transfer consisting in the execution of an order for the transfer of a sum of money from one bank account to another. It's characterized, I'm hesitant to read on. The court has heard this too many times, so if I can jump to 80. That interpretation doesn't presuppose any particular method for effecting transfers, which may be done using accounting entries. That is so in the case of transfers between customers of a single bank or between accounts of a single individual who acts as both the person giving the order and the recipient. At the hearing, ATP stated that although the transfer of sums from a current account to a savings account belonging to the same account holder doesn't alter either the creditor or the amount of the debt, the terms and conditions relating to the debt owed to the bank will, by contrast, be altered. A transfer between two accounts belonging to the same account holder will be carried out using accounting entries, from which point new terms and conditions will apply to the debt in question. I take that to be stated by the court in agreement, it doesn't actually say so.
Can I just check the following paragraph 70? The employer presumably had an occupational pension scheme,
Yes.
Under which it was under a liability to the employees to make contributions into a pension fund held by the pension company.
Indeed.
And the taxpayer was, if I'm following this, was crediting to the accounts with the pension scheme, with the pension fund,
Yes.
the amounts of the contributions due by the employer.
Indeed. I don't know how much discretion it had,
Yeah.
or whether it had tram lines, but that is exactly what it was doing.
So it was actually, so from the last sentence of paragraph 70, it seems that it was actually affecting a legal change by, first of all, it was actually crediting the contributions to the accounts with the pension fund, and thereby transforming a debt owed by the employer to the worker into a claim that the worker held vis-à-vis the pension fund.
My lord, indeed. And if you look at page 710 at para 27, it's pretty much as
Paragraph.
my lord, 27 on page 710. It's pretty much as my lord Lord Reed indicated.
Right.
And the website can be accessed to see how one stands.
I see. Yes. So the employer transfers a lump sum, effectively putting it under the control of ATP, and then ATP then pays individual amounts out of that into the accounts held by the different
Indeed.
workers with the pension company.
Well, this is accruing pension, so it's not actually paying it out, I suspect. It's just on the ledger noting that their pension will go up by 5p a year because of this particular contribution the employer has
Indeed.
made.
But I presume, and it's only a presumption, that if at any point they can take money out, then this will obviously tell them what's available.
Yeah.
Again, I'm not sure of the detail.
Yes. One can see it's affecting a transfer of a kind that's been described time and again in the case law.
And it really does, it does two tasks from my point of view. One, it just indicates the flexibility of the 13BG3 concept of execution and transfer. It will mould itself to any appropriate situation. And secondly, it explains why there are references in the European cases to accounting entries or affecting a transfer by means of accounting entries.
And maybe also explains that whole repetition of you don't have to be a bank to fall within the exemption.
Yes.
Yeah.
Yeah.
It ticks quite a few of these boxes.
Yes. Yes, the ladyship I see is quite right from paragraph 27. There's only a single payment made by the employer, but it's an ATP which actually affects the credits to the accounts of the individual employees, and thereby, which has the legal consequences described in paragraph 7.
Indeed. So that's step one.
Then they make an analogy with a more usual or commonly occurring, perhaps, instance of a ledger transaction, which is when a bank customer transfers money from one account to another, from a savings account into a current account, whereafter it presumably doesn't earn any interest and the terms and conditions change. That's at 80. I think that's what that's.
So that's step one, that's European law. And then English law, so I invite the court to close or to move on from that page. English law in Mr. Justice Carr's decision, as he then was in Mom versus Barclays, it's 1174, that's tab 34. Obviously, we're not a pension fund, so I have to establish that there is legal significance in the fact that my clients maintain the only ledger. The Mom case...
Page number again?
My lady, it's 1174, tab 34 of the physical bundle. And the Mom case, decided in 1975, was one of those cases where one party to a debt failed, and if I could just summarize it, because the extreme detail doesn't matter. This was the time when punched cards were what was used on computing, and the party, the other party, counterparty, heard about the failure and just presumed that it didn't get any money. It then discovered that, unknown to it, the day before the failure became public, the bank had actually for whatever reason, credited or treated the money as having been paid, and its computer ledger on, say, the Monday night treated the money as paid, and then on Tuesday the bank heard about the failure. I don't think there's any suggestion of dishonesty, but it just quietly scrubbed the ledger out, and it was only by chance that later the payee discovered that it had indeed briefly been credited with the money. So it's a very rare case perhaps now. And Mr. Justice Carr had to decide, well, what's the effect of the entry? And the reason I'm citing it is because he took the view that the bank's ledger, once it showed the payment was deemed to be due. So it's a very short point. It's perhaps trite law. The page 1183, his lordship tells that story, and the story of the discovery, and he says at letter, just above letter G, the issue, so 1183, just above letter G, the issue is whether or not a completed payment had been made by the defendants to the plaintiffs on June 26th. That's a question of law. If the answer is yes, it isn't contested that the plaintiffs have a good cause of action. Dropping down a couple of lines, speaking of a lawyer and a banker, he says, I think that both would say two things. First, that in such circumstances, a payment has been made if the payee's account is credited with the payment at the close of business on the value date, at any rate if it was credited intentionally and in good faith, and not by error or fraud. Secondly, I think that they would say that if a payment requires to be made on a certain day by debiting a payor customer's account and crediting a payee's customer's account, then the position at the end of the day, in fact and in law, must be that this has either happened or not happened, but that the position can't be left in the air. And pausing there, one thing I didn't tell you is they both had accounts at the same bank.
I was just going to ask you.
Yes, so sorry, I left out.
Customers of the same bank.
Exactly, I left out the most important.
That's why the transfer would be effective.
Indeed. So, and his lordship goes through Isles and Ellis. The detail may not matter. Mr. Staunton, as he then was, cited a contrary authority, but the conclusion was that because the entry had been made, then. So that's really the short point. Court of Appeal, I won't open it. The Court of Appeal at paras 103 to 109, that's an electronic bundle 211, said no. As I've already indicated, the real transactions took place through the clearing banks. And with great respect to the Court of Appeal, one understands that sentiment. This is the sort of rule that only becomes relevant when there's a failure or some event which makes it material to know when the credit entry was made. So I accept it's a technical point, but there has to be a ledger somewhere. Shawbrook is a bank after all, and it is lending in rather large sums. And one can't pretend to oneself, even in the electronic age, that one doesn't need a ledger and that it wouldn't have the legal effects of the MOM type. So that's a short second.
Well, does it or doesn't it have that? Does this ledger have the same legal effect as the ledger in MOM?
Well, lady, obviously I should have said it more clearly. I apologise. The answer is it must do, because Shawbrook is a bank. We are keeping its books. On this occasion, it has subcontracted its ledger to us, paragraph 42 of the tribunal's decision. And if the MOM case is still good law, and I know of no reason why it wouldn't be, then it follows that this ledger has that evidential significance or legal significance, as Mr. Justice Carr said. It's not up in the air at the end of the day. And what I have in mind, perhaps I should be a little more clear, the Court of Appeal is right in what it said, of course, But if there's a morass of cash, if Shawbrook go under, and there's a morass of cash knocking around in its bank accounts, then the first thing the auditors would look at, would ask for, is the ledger.
This is a ledger not of a bank account, but of a mortgage account.
Indeed, and a mortgage account, a pension account. The important thing is that it's a ledger which deals with financial liabilities, which is a debt in this case. That's the best point of entry in terms of transactions concerning payments, transfers and debts. I position this as a more debt-focused point, but it's not a second-class ledger, with the ATP being a first-class ledger, as it were. It's a first-class ledger which has potentially great legal significance, although only in situations probably of bankruptcy. It is a short point.
And what's wrong, do you say, with the last sentence of paragraph 107, page 157?
Forgive me.
The act of inputting a credit entry in a loan account made no change in the legal and financial relationship between Shawbrook and the relevant borrower. It simply recorded or reflected the transfer of funds from the borrower's bank account to Shawbrook's bank account.
I have been at pains to say, as far as it goes, there's nothing wrong with that. But coming the other way, that doesn't denature the significance of the ledger.
This could be a very significant point for the mortgage industry, because I don't know how often it happens that actually a borrower is not in funds, up pops the direct debit into their mortgage account, which then has to be unwound when everybody realises that actually wasn't enough money in the account. I mean, is that something that happens? Because
Well, it must happen.
but you're saying, too bad, that payment is treated as having been made by the borrower
Well,
for that month.
I'm not saying that. Because between the borrower and the bank, the borrower can't be heard to say or to pretend that it had paid, but between the bank and its creditors, it's more the reverse. It's more where the bank goes under, because we're not going to have a MOM type situation. But if there were an insolvency in terms of the bank, but the bank had registered a sum of money as having arrived, and maybe it didn't stay in the account, or maybe money was leaking, or whatever. It's the other way around, lady, that I'm really thinking about this, that a borrower could say, I'm down as having paid that money, and that's my slice of... So it's super rare occurrence, hopefully. So, and I accept it's a very technical point, but the alternative is to say these ledgers have no legal significance at all, and that instinctively perhaps that's something that one should avoid. It comes ultimately from the fairly complete subcontracting by Shawbrook to Target of everything to do with this relationship.
Are you envisaging a situation where the entry in the ledger has been made in error?
Well, it may not have been made in error, but it may be the only evidence of the true position. Having said that...
I think the judge made a carve-out, didn't he, for error or fraud?
Yes, he did.
He did.
Yes.
But...
And it won't be the only evidence, will it?
No, it won't necessarily.
The bank's client will say, well, this was a mistake. I never gave that instruction, or my bank misunderstood, or something like that.
Indeed. But in MOM, I haven't explored the limits of error, but in MOM we know that the bank realised that it couldn't recoup itself from its other customer because they went under. So the bank, I mean, there must be an element of error, perhaps not, in the bank's conduct. I mean, the court presses me for examples. I'm doing my best. But the alternative is to say, well, it doesn't really matter. And I would urge upon the court not to reach that conclusion.
It does matter because it's useful to have a ledger, but I thought the point you were making was because the ledger is, in effect, almost like registered land, the title comes from registration, so that is whatever actually has happened, that is what the legal position is, which is taking a step further than just having a useful ledger which you can look at and is fine until somebody points out that actually it's inaccurate, at which point it can be corrected.
Yeah.
But I think you have to go a little bit further
I do.
And say it can't be corrected because whatever it says is correct, whatever has actually happened.
Yes, I do have to go further, and the Court of Appeal took the view it took, which was not articulated, if I may say so, as clearly as it has been here. But the Mon case must mean something, and Mr. Justice Carr did hold the bank to the entry it had made. So to that extent...
Right, but there was no mistake in that entry. That accurately reflected the customer's instructions to the bank acted upon by the bank.
Indeed it did, only the customer didn't have any money. So the bank someone might argue, well, that was the mistake. They should have waited until they could actually move the funds. But I think the court has my point, I can't really develop it any further than I have.
What was recorded in the ledger was the fact of the transfer from the borrower's bank account to Shawcross.
Yes.
Is the point made by the Court of Appeal, paragraph 107. That's not analogous with the situation in Mon.
It's not, my lord, but in a situation where, say, Shawbrook fails, and one has a mass of money and one has to work out to whom it belongs, it may be material, and perhaps not every receipt has been recorded. I'm positing perhaps a rather imaginary series of events. I'm trying to posit a series of events where you don't necessarily have primary evidence. And someone is saying, but I do remember writing a check. It's much easier if one's dealing with electronic transfers because one has a record. But if someone writes a check or does something more analog and they can't retrieve the check stub, if they can point to an entry in the ledger, their position is secure, I would say. But as you can see, I'm having to find perhaps situations which are rare, but nonetheless not so rare that it could never come up. I can't put it any higher than that. Shall I move to the next point, which is the card protection plan point? I can take this, obviously, depending entirely on what the court wants to hear, quite shortly, in the following way. The card protection plan point never comes up in Europe in those cases such as Nordea and SDC and Cardpoint, because there's never any doubt what the bank wants. Whether the thing it gets is taxable or exempt, what the bank wants is something to do with moving money, to do with banking. And therefore, it's not theatre tickets, it's not dental work. And therefore, there isn't really a card protection plan issue. In the UK, we do traditionally have a card protection plan issue in these cases. One had it in FDR, in EDS, and in the current case. And it always resolves itself around either the banks really wanting bookkeeping services, and that was very much the FDR debate, or a generalized statement of administration services, which is, I don't do justice to my learned friends on this point, but my learned friend will deal with that. And the answer proposed, well, the answer in both FDR and EDS, and the answer for present purposes from the first tier tribunal, page 271 at 109 to 116, the answer has always been it's a bank, and what it ultimately wants is the money. And therefore, it wants the money at the right time. So that's page 271, 109 to 116. And what happens here, we've got two parallel versions of the CPP analysis. One on the basis of the primary basis, which is that the debt collection coda applies, and the alternative on the basis that the debt collection coda does not apply, and that it's a simple exemption. So the debt collection basis, it actually starts at 270. It goes from 110 to 112. That's to be my next topic. And the alternative, based on Article 1351D, is at 113. In fact, although the learned judge structures them differently, 110, 112 being, does the bank really want debt collection? And 113 being, does the bank really want transactions concerning payments and transfers? It's the same thing commercially. The bank wants what it wants. And which bit of the legislation it fits into.
I thought the CPP point was whether this is a composite supply, the predominant part of which is something other than a 13B D3 exemption.
My lady, exactly right.
But I thought the debt collection point was whether, if this is a single supply, is it actually debt collection?
Well, that's the next point. But I explain how I've organised this.
Right.
I'm sorry if it's unhelpful.
No, that's how you organise it's fine, as long as I've got...
No, but I'm not trying to muddle up too. So we don't get to car protection plan if I haven't persuaded the court today of anything. So that's simple. If the court has been persuaded to some extent that it is minded to conclude that some or all of what we get is exempt, then I have to, the next gauntlet, as it were, that's on the ground from the taxpayer's point of view, is to satisfy the court that that exempt thing is not overwhelmed by some taxable other thing which is more predominant.
So can I just check? If we get to this point, do you accept it is a complex supply, and so we are looking for whatever is the predominant element?
We've always accepted
Yes,
it's a single supply.
Right.
So, and I jumped a few steps by saying what I said. Wanting the money is bad news for us if you're against us on debt collection, because what the learned judge has held between 110 and 112 is, since she had decided that debt collection was, as it were, the objective analysis, the analysis is therefore that would have been our predominant desire, would be debt collection, and therefore that we would be predominantly desiring a taxable service. Then, very helpfully, she says, but if I'm wrong on that, and I have to work out whether your predominant desire is for an exempt service, then that's what you predominantly desire. That's 113. The point I'm making is that although they are dressed in different clothing, there is a unitary predominant desire on the part of the bank in my client's situation to be paid and to receive its interest. So, and maybe I'm tilting at a windmill from the past, but FDR, the position was that it was really bookkeeping with a little bit of money movement on the side, and that ultimately didn't succeed. Bookkeeping of 20 years ago has become administrative services, and certainly on the 113 point, where assuming the court is persuaded that there is some element of exemption here, of course, we wish to receive our funds in an orderly way, in a timely, well-organized way, in the correct amount, with the appropriate interest and so forth applied. But if one thinks of things as a pyramid, the top of the pyramid, in terms of what we're selling to Shawbrook, is a flow of funds at the right time, in the right amount, from the right people, and a trajectory in terms of the curation of the debtor-creditor relationship over time, which will bring the whole thing into landing, back to zero at an appropriate moment, with the right money paid. But it is all about the money. And therefore, that's a shield for me, to some extent, in 113, because I'm basically saying it's the exempt payment stroke transaction service that we are to be taken as supplying to our banking client. It becomes a sword in my learned friend's hands at 110 to 112 when they say, well, what you're really after is debt collection. I'm not conceding that should influence the court in its analysis of the next point I'm going to come to, which is the debt collection point. I'm just saying that if there is a contest, unsurprisingly and hopefully frankly, I'm saying the bank wants what it wants, and it's for others to decide what that amounts to in terms of the taxation analysis. That's all I'm saying. But what the bank doesn't need is some freestanding supply of administrative services. And that's my short point on the car protection plan point. So I move on now to debt collection. So now...
Yes, you may not finish it this afternoon,
No.
but that clock is slightly fast.
Yes, 6
So
minutes.
you can carry on for about 5 minutes if you would like to.
May I just get it going? And
Yes, certainly.
It'll be 6 minutes less tomorrow. I'm most grateful. So on the debt collection point, if I can give this, give some parameters. First tier decide the debt collection point against us at paragraphs 94 to 108, at pages 267 to 9 in the electronic bundle. We respond at some length in our case at electronic pages 125 to 137. The lead case is, I'm just checking. Yes, that's correct. And the issue, of course, is if one has the exemption handy, the reference, obviously, at the end to debt collection services. The authorities, which I'll turn to briefly in the morning, or the principal authorities, are the AXA case, which is tab 8 at page 652. That's the AXA case in the European Court. That was the case where the European Court said of a parallel dental plan that it was exempt. I haven't cited that case to you, but it was taxable, was potentially exempt, but was rendered taxable by the debt collection tailpiece. I will also show you Lady Justice Arden's, as she then was, comments in the self-same case, AXA in the Court of Appeal, tab 20, page 924, at 942, paragraph 51, where Her Ladyship muses, I think I can use that word, that there must be a restriction placed on the debt collection tailpiece for normal banking operations. Some might use the phrase, the sphere of financial transactions, because that would then lead to the following agreeable outcome. It would mean that when banks and their legitimate subcontractors are engaged in the business of causing the transfer and payment of debts, they are not caught by the tailpiece, but whereas those outside the sphere of financial transactions, solicitors, bailiffs and others, when they seek to recover, or persons who deal in debts, who buy up debts for their own speculative reasons, they are redelivered, as it were, to the mainstream of taxable activity. And there is also one other case, well, there are two other cases. There's DPAS itself in the court, the European Court, where the Advocate General makes some remarks. The court is tight-lipped on this point, saying it doesn't need to refer to what its brother judges had earlier decided in the AXA case. And then last of all is the European Court decision of MFKG, tab 7, page 635. That proposes, at para 78, that there be something called a circumscribed financial transaction, dealings in debt, and the tailpiece be restricted in some way around that concept.
I'm so sorry, I missed the page number.
That was para 78, page 635, my lord.
Thank you very much.
So I think I've used up my thinking time.
635, I think, is the, this is MKG.
Yes, I think I said MFKG. I should have said MKG.
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 Yes, is this a convenient moment?
Yes, it is. I'm most grateful for the extra time.
Very well. Well, we'll adjourn for the day and sit again at 10:30 tomorrow morning.